Good evening, friends. Let us dive into another case law which has been recently added into the syllabus of Advocate on the Court. This is regarding interplay between arbitration agreements under the Arbitration and Conciliation Act 1996 and Indian Stamp Act of 1899. This was decided on 30th December 2023. As far as the constitution of bench is concerned, it includes Honorable Chief Justice D.Y. Chandrachud, Justice Sanjay K. Kaul, Justice Sanjeev Khanna, Justice B.R. Gwai, Justice Surya Kant, Justice Jamshed B. Pardiwala, and Justice Manoj Mishra. Friends, the question to be decided is whether an arbitration clause in an unstamped or inadequately stamped contract is enforceable. I am repeating the question, whether an arbitration clause in an unstamped or inadequately stamped contract is enforceable. Now, let us first dive into factual background. In 2011, a division bench, that is two-judge bench of the Supreme Court, in SMST estate case, held that an arbitration agreement in an unstamped contract is invalid. Then in February 2023, a three-judge bench in Bhaskar Raju followed this ruling in SMST estate with approval. In 2021, a three-judge bench of the Supreme Court in NN Global I took a view contrary to SMT state and held that non-stamping of the contract would not invalidate the arbitration agreement contained in it, and arbitration agreement can be acted upon. Given these conflicting decisions of the court, a constitutional bench of 5 judges were set up to decide the issue. In December 2022, a curity petition was filed in the Supreme Court for reconsideration of the Bhaskar Raju decision. Before the curity petition was finally decided, in April 2023, a constitutional bench of the Supreme Court by 2-3 majority in NN Global 2 held that NN Global 1 was incorrect and upheld the view taken in SMST estate. The court held that an unstamped contract is void, does not have any legal effect, and hence the arbitration clause in an unstamped contract is not enforceable. Later, while hearing the curity petition in Bhaskar Raju and considering the larger ramifications and consequences of the decision in NN Global 2, the Supreme Court referred the case to a 7-judge bench. The present case, interplay between arbitration agreements under the Arbitration and Conciliation Act 1996 and the Indian Stamp Act 1899 is this reference to the 7-judge bench to decide the correctness of the Constitution Bench decision in NN Global 2. So, Honorable Supreme Court gave its decision and held that the arbitration agreement or arbitration clause contained in an unstamped or inadequately stamped contract is valid and can be acted upon. The court also held that the contract which is not stamped or is inadequately stamped is not void, but is only inadmissible in evidence. The court declared that decisions in NN Global 2 and SMST estates were incorrect. The judgment of the court was authored by Honorable Chief Justice Chandrachud. Honorable Justice Sanjeev Khanna wrote a separate concurring opinion. Now let us dive into reasons for the decision. The difference between inadmissibility and voidness. Honorable Supreme Court noted that a void agreement is unenforceable in the court of law. That is, it cannot be given effect to, while an inadmissible document can merely not be introduced as evidence in a court of law. The court observed that while Section 35 of the Indian Stamp Act makes an unstamped or inadequately stamped document inadmissible in evidence, non-stamping under the Stamp Act does not render the document void. The court noted that non-payment of stamp duty is a curable defect, as the Stamp Act itself provides under Section 42, subclause 2, that once the required stamp duty is paid, the instrument will become admissible in evidence. In contrast, the court noted that there is no procedure by which a void agreement can be cured. Minimizing judicial interference. The Supreme Court noted that one of the main objectives of the Arbitration and Conciliation Act 1996 is to minimize the supervisory role of the courts in the arbitral process. Section 5 of the Arbitration Act states that for matters covered by the Arbitration Act, no court can interfere unless the law explicitly allows for it. Section 5 allows the legislative attempt of limiting judicial intervention during the arbitration process. Section 8 of the Arbitration Act mandates courts to refer the party to arbitration if there is prima facie a valid arbitration agreement. While referring party to the arbitration, the court cannot conduct a mini trial by allowing parties to produce the evidence regarding validity of an arbitration agreement. Section 11 of the Arbitration Act deals with appointment of arbitrators. Section 11 allows intervention by courts only when parties fail to appoint an arbitrator. Section 11, subclause 6A, inserted by Arbitration Amendment Act of 2015, states that while allowing an arbitrator, the court shall confine itself to the examination of existence on arbitration agreement. The court found that the intention of the legislature in adding Section 11, subclause 6A was to limit the scope of referral court's jurisdiction to only one aspect, the existence of an arbitration agreement. The doctrine of competence. The Supreme Court noted that the doctrine of competence states that arbitrators are empowered to decide on their own jurisdiction. The doctrine of competence allows the arbitrator to decide on all issues arising out of the underlying contract, including the existence and validity of the arbitration agreement. Enshrining the competence principle in Indian arbitration law, Section 16 of the Arbitration Act empowers the arbitral tribunal to rule on its own jurisdiction, including ruling on any objection with respect to the existence or validity of arbitration agreements. The court noted that once the arbitrator decides a matter, Section 34 of the Arbitration Act allows application for setting aside arbitral decision. The court noted that one of the grounds on which an arbitral award can be set aside is that arbitration agreement is not valid under law. This indicates that the Arbitration Act does not contemplate the court determining the validity of an arbitration agreement before the arbitrators have had a chance to decide the issue first. Justice Khanna, in his separate opinion, held that an objection related to insufficient stamping or non-stamping of the underlying contract can be decided by the arbitrators. Arbitrators arbitration acts silence on stamp duty. The Supreme Court noted that the Arbitration Act is a self-contained code and hence provisions of other laws cannot interfere with the working of the Arbitration Act unless the Act specifically allows for it. The court noted that Parliament was aware of the Stamp Act when it enacted the Arbitration Act. Yet the arbitration does not specify stamping as a precondition to the existence of a valid arbitration agreement. Intent and purpose of Stamp Act. The court noted that the Stamp Act is a fiscal legislation to protect the interests of revenue for the governance. It is not intended to arm litigants with a weapon of technicality by which they can delay the resolution of the case. The court held that arbitrators will be bound by Stamp Act and will have authority to enforce the provisions of the Stamp Act. The court declared that interpretation of the law ensures that provisions of the Arbitration Act are given effect to while not detracting from the purpose of the Stamp Act. That's all. God bless you all. See you again. Enjoy your life. Don't forget to subscribe.